Hello, everyone. I would like to thank the Compliance and Investigation Practice Group of the World Law Group for inviting me to share recent enforcement trends in Argentina affecting our practice. Today, I would like to share a few lessons arising from the recent conviction of Lázaro Báez, one of the closest business associates of former presidents of Argentina, Néstor and Cristina Kirchner. Báez was recently convicted to 12 years of imprisonment for laundering the proceeds of corruption in obtaining public contracts and for laundering the proceeds of tax fraud. Other 21 individuals and 5 legal persons were also convicted on money laundering charges. Together with the imprisonment sentences, the court imposed combined monetary penalties for more than $4.3 billion, an absolute record for Argentine case law. The facts of the case are very easy to understand. Baez created a construction company when Néstor Kirchner won the presidential elections in 2003. Before that, he was just an employee of the Bank of Santa Cruz, the province Kirchner used to govern before becoming a president. Since then, Baez became one of the major public contractors of the country. The decision is not only the first one applying very harsh pecuniary sanctions, it is also the first one sanctioning legal persons for money laundering and the first one in applying a leniency agreement with cooperating defendants. So let me briefly explain the court reasoning in these three very important topics for our practice. For the first time since its enactment in 2016, the court applied the so-called repentant law to a defendant that had cooperated with the investigation. The court sentenced him to 5 years of imprisonment, noting that the conviction was reduced by 3 years compared to the 8 years that would have corresponded to him if he had not cooperated as a repentant defendant. The law in Argentina only allows courts to reduce the sentences from 1/2 to 2/3 the time it would have corresponded in absence of cooperation. The reduction of the sentence in this case was close to the maximum allowed by the law, which in our view is a very good sign for incentivizing other defendants to come forward in future cases. A second important topic that I would like to highlight from this case is the combined monetary penalties imposed by the court. One may wonder how the laundering of $60 million end up in a conviction of combined monetary penalties of over $4.3 billion. Well, the law in Argentina allows courts to fine convicted launderers with a scale from 2 to 10 times the amount of each transaction. The 4.3 billions then result from the sums of the fines imposed by the court to each convicted person. For instance, Baez was sanctioned with 8 times the amount laundered in the transactions he participated in, which amounts to almost $500 million. In addition, the legal persons he owned and managed were also convicted and fined with different scales, depending on their participation in each transaction. In spite of the fact that the sanctions were applied in accordance with the law, we believe the defense would appeal on grounds of proportionality. Finally, the decision sanctioned 5 legal entities that were neither previously charged nor heard. In so deciding, the court explained that in money laundering cases, the sanction of a legal person is an accessory consequence of the conviction of the natural person who acts on behalf of or for the benefit of the legal entity. The court developed an additional argument associated with the organizational failure of the sanctioned legal entities, pointing out their absolute lack of compliance programs. For the court, this constitutes, and I'm quoting, corporate mens rea in the form of a deliberate ignorance of the internal risk prevention systems. This argument obviously contrasts with the previous one, since penalizing legal entities for not having preventative and control systems would only work in the context of a corporate liability system based on the organizational failure of the legal person. We believe the court mixed both arguments up when it should have used this second argument only to determine the amount of the sanction to the legal entities as required by the law. In short, the court in Baez sparked local legal debates on corporate criminal liability, criminal pecuniary sanctions, and cooperating defendants. After years of limited enforcement, such debates were very much awaited by the local legal community and would certainly encourage other courts and litigants to further resort to these legal instruments. Thank you very much.